The enormity of the injustices involved under this statute merely serves as indicia of how these civil liabilities amount to a denial of due process to the individuals involved. As I started to say before, no matter how we articulate this, no matter which theory of the due process clause or which emphasis we attach to, no one can articulate it better than Richard Loving when he said to me, "Mr. Cohen, tell the court I love my wife, and it is just unfair that I can't live with her in Virginia." I think this very simple layman has a concept of fundamental fairness and ordered liberty that he can articulate as a bricklayer that we hope this court has set out time and time again in its decisions on the due process clause. With respect to the legislative history urged by the state as being conclusive that the 14th Amendment did not mean to make unconstitutional state statutes prohibiting miscegenation, we want to emphasize three important points. One, only a small group of senators in any of the debates cited ever expressed themselves at all with respect to the miscegenation statutes. There are perhaps 5 or 6 that are even quoted, and these were for the Freedmen's Bureau Bill and the Civil Rights Act of 1866. If absence of debate ever has any influence at all, this is a classic case. Nowhere has the state been able to cite one item of legislative debate on the 14th Amendment itself with respect to anti-miscegenation statutes. Not one item. All of their references are to the 1866 Act. And again, we point out that those comments were very carefully worded by both proponents and opponents of the bill. Again, we carefully point out that their own record of the legislative history shows that there were just as many senators who believed that indeed, especially the southern senators whose states had anti-miscegenation statutes, there were just as many of them who did believe that the passage of the Civil Rights Act of 1866 would invalidate such an act. Their own passages that they printed in the brief, around pages 30 through 33, are replete with support for our argument that at best, the legislative history is inconclusive. And as this court has found before, and we hope will continue to find, the 14th Amendment is an amendment which grows and can be applied to situations as our knowledge becomes greater and as our progress is made, and that there will be no problem in finding that this set of statutes in Virginia are odious to the 14th Amendment.